In this video, we shall discuss Article 19(1)(a) of the Constitution, a fundamental right dealing with freedom of speech and expression, a very important topic for the civil services examination. This video you're about to watch has been extracted from my Unacademy Platinum Polity course. My new Polity batch for CSE 2027-28 on Unacademy Platinum starts on the 15th of June. I invite you to experience Unacademy Platinum for free. My first 3 lectures are available for all. The link is provided in the video description. Submit the form and experience Unacademy Platinum. Now let's discuss Article 19(1)(a) of the Constitution. We will have to focus on 4 articles. Article 19 to 22. Let's look at Article 19. Protection of certain rights regarding freedom of speech, etc., etc. Article 19 begins with all citizens, which means this fundamental right is not available to aliens. This fundamental right is exclusively available to citizens. Just like Articles 15, 16, now we encounter Article 19. These 3 fundamental rights exclusively available to citizens. And then within Article 19, there are some rights. 19(1)(a). That's how you write these articles. 19(1)(a), 19(1)(b), C, D, E, F, G. These rights which are provided under Article 19, we call them natural rights. This is natural. This is synthetic. Natural, it occurs naturally. Synthetic, which is developed, which is manufactured. We say these rights under Article 19 are natural rights because they occur naturally to an individual because of the accident of birth. Because once you are born, over a period of time, you start speaking and expressing yourself. You start moving here and there. You start residing and settling in different parts of the country. You also start taking up a profession or a trade or an occupation. These rights are called natural rights because they occur naturally to an individual because of their birth. And we will discuss all these rights one by one, but we will focus more on Article 19(1)(a) because it is almost always in the news. And this is where a large number of questions have been asked, primarily in the mains examination. Article 19(1)(a), which is what we call freedom of speech and expression. So right to freedom, Articles 19 to 22. First, Article 19. Article 19 says protection of certain rights regarding freedom of speech, etc. And in that, first we will focus on Article 19(1)(a), which is freedom of speech and expression. And what do we mean by freedom of speech and expression? It's an innocent sounding article. All the citizens, they have the freedom to say whatever they have to say, to express whatever they want to express. Say means, can they give a speech? Say means, can they write something? Can they make a movie? Can they write a song? Can they express themselves through a cartoon or through a painting or through any other art form? Use whichever medium you want to use, whether it is print media, electronic media, digital media, whatever media. You have freedom of speech and expression. Why is this fundamental right important? For that, we have to go back to what former Chief Justice of India, Patanjali Sastri, spoke of. Imagine, we are a democracy. And we are a democracy because there are also periodic elections which happen. Every 5 years, there are elections. And how do you get to decide which political party to vote for? For example, Kaushal, have you ever voted
Yes, sir.
for which political party?
Sir, BJP, sir.
BJP. How do you decide whether to vote for BJP or Congress or Aam Aadmi Party?
Sir, I really want to say that, sir, because in my family member has said that you have to be vote for this person.
Okay.
But sir, uh, sir, at this point of time, I thought my right is violated. But after that, when they said
Got it. Got it.
I got
Anyone
it.
from Bengal here?
Yes, sir.
Who?
Susanya.
Have you voted?
Yes, sir.
Which political party?
I don't want to disclose.
Okay, very good. That's the good answer. Kaushal, that's what I wanted to teach you. Don't reveal your choice. But how do you decide which political party to vote for and which political party never to support? For that, you need information. For that, you need strong knowledge about different candidates contesting the election, ideology of the political party, and the track record of the governance of that political party. For example, Delhi was beautifully governed by Sheila Dixit. For example, beautifully governed by Sheila Dixit for 15 years. But we needed a different political party because otherwise you become dictatorial. And then people voted for Aam Aadmi Party. What if in these elections, other political parties are not allowed to criticize the previous government or the incumbent government? Then how are we going to educate the people? If in the election rallies, I can only ask you, please vote for me, without telling you the reason that you should vote for me because the current government is casteist or communal or corrupt or pro-industry, or I am part of the ruling political party, I am asking you to vote for me. Why? Because we have eradicated patriarchy or corruption or dynastic politics. We have developed ease of doing business in India. Unless and until you have the freedom to say this, can there be a democracy in India? No. Can there be political education in India? No. I need to make people aware that this is your right. I need to make people aware that these are the challenges that we are facing as a nation. And for resolving these challenges, I am a better candidate, not this person. This is all part of political education. And if freedom of speech and expression is not provided in the constitution, then what will happen to political discussions? There won't be any political discussion in the society. There will be no political education in the society. And it is this political education which is essential, necessary for functioning of the government. And that is why Patanjali Sastri, former Chief Justice of India, said this freedom of speech lies at the foundation of every democratic organization. If India is a democratic identity, for that freedom of speech and expression is a must. Because if you don't have this free speech, you can't criticize the government. And if you don't criticize the government, there is no political education. If there is no political education, how can you hold this government accountable? What if you are not allowed to criticize the government on the GST? Not allowed to say something on Operation Sindoor? Not allowed to say something on some important matters being discussed by the government? Then how can we be a democratic country? That's why Patanjali Sastri said this is at the heart, this fundamental right is at the heart of our constitution. Similarly, look at the Supreme Court of India. We have Supreme Court, and Supreme Court has the power of judicial review. Right or wrong? Right. Supreme Court has been using its power of judicial review by employing what we call judicial creativity. And it is through this judicial creativity that the rights originally not conferred by Constitution have been made available to citizens. Anybody can teach fundamental rights, but there are some who will use their creativity, maybe the voice modulation, maybe examples, maybe humor, some form of creativity to make students understand better. Creativity. Judiciary has the power of judicial review. It will review the provisions of the Constitution, interpret the provisions of the Constitution creatively, and give us those rights which originally were not part of the Constitution. And those rights which originally were not part of the Constitution but were given to us thanks to the Supreme Court, we call them inferred rights. Which means now we are talking about more rights. First, what are rights? Rights are some things that you can claim from the state. Within rights, we have constitutional rights, statutory rights. Within constitutional rights, we have fundamental rights, other constitutional rights. Within fundamental rights, now we have natural rights, those rights which are under Article 19. And within them, we have now inferred rights. That means we infer from an article, from a fundamental right, and give more fundamental rights which originally were not part of the Constitution. And the second highest number of inferred rights Supreme Court has given us under Article 19(1)(a), and that is what we call Article 19(1)(a). It is the second most evolved fundamental right. That means under Article 19(1)(a), more inferred rights have been conferred. Second most. And which is the topmost? Article 21. And what are these inferred rights? There is something called Flag Code of India. National flag. How do we hoist the national flag? What should be the dimensions of this national flag? What should be the dimensions of the orange, white, and green, or saffron, yellow, saffron, white, and green? All these dimensions are provided by the Flag Code of India. Of what material should this national flag be made of? Can you disrespect this national flag by using it as an underwear, as United States does? No, you can't do that because you have to respect the national flag. And this Flag Code of India, as it existed previously, it said you cannot hoist the national flag at the top of the private building. It can be hoisted only at the top of the government building. Can you wear the brooch of this national flag as a badge next to your heart? You can't do that because that is violative of Flag Code of India. You can only use this national flag on top of the government vehicles, on top of the government offices, on top of the legislatures and the Supreme Courts. One citizen who later on became the member of the parliament as well from the Congress and now is part of the BJP, Mr. Naveen Jignal. He approached the Supreme Court. My lord, do I have freedom of speech and expression? Court said, yes, you have. Article 19(1)(a). It talks about all the citizens, and you are a citizen, all the citizens, you have freedom of speech and expression. My lord, I want to express my love for my country. But the Flag Code of India says you can't use the national flag and hoist it at the top of the private building. I want to hoist it at my office, on top of my house. I want to wear the badge of the national flag close to my heart so that every breath of my heart, every beat of my heart would resonate with the national anthem. Supreme Court said, don't worry. If Article 19(1)(a) talks about freedom of speech and expression, we are telling you that you have another fundamental right. And that fundamental right is flying the national flag is a symbol of expression, and it is a fundamental right under Article 19(1)(a). This became your fundamental right, although not provided by the Constitution, but judiciary employing its judicial creativity, expanding the scope of Article 19(1)(a), interpreting it and giving us more fundamental rights. Another organization, Association for Democratic Reforms. This is an organization which works in the field of electoral reforms. For example, ADR was the petitioner in the electoral bond scheme. ADR approached the Supreme Court and said, dear Supreme Court, do we have freedom of speech and expression? I said, yes, you have, Article 19(1)(a). Sir, if we have free speech, does that mean in this free speech we can ask questions as well? What sort of a question is it? You have freedom of speech, that means say whatever you have to say. And if you have to ask questions, you can ask questions as well. But to whom? My lord, we want to ask questions to the candidates who are contesting elections. You want to ask questions to the candidates contesting elections, but what sort of questions and why? Because, sir, we want people to make an informed choice. Informed choice in the sense, you have to enroll in a coaching institute for the civil services examination. And there are 10 coaching institutes lined up. And you have to choose one. How will you choose if you have no information? Who teaches in these institutes? What is the background of these teachers? What is the track record of these teachers? Whether answers will be evaluated or not, whether mains test series will be part or not, whether prelims test series will be part of not, whether mentorship would be included or not, whether current affairs would be taken care of not. Unless and until you have this information, can you make a right choice? You can't. If this is about choosing a simple coaching institute, how about choosing a representative who is going to make law for the entire country? If there are 20 candidates contesting the election, we need information about them. Without that information, we will not be able to decide who is the right candidate for us. What sort of information? My lord, please tell all these candidates who are contesting elections that you file an affidavit. And in that affidavit, they mention their educational background. They mention criminal cases which are pending against them. They mention assets, movable assets, immovable assets, which are in their name as well as in the name of their spouses. Why? Because if this information is provided to us, then citizens would be in a better position to choose the right candidate, the right member of the parliament. So I may be choosing somebody who has more rape cases against him than somebody who is clean. Because ADR data tells us 40% of the people in Lok Sabha, they have criminal past. ADR data says that the more criminal cases are pending against you, the more chances you have of becoming a member of the parliament. Does that reflect the choices that people make? That's a separate matter altogether. But the point is, unless and until you have this information, you may not be in a position to make the right choice. Supreme Court said, don't worry. If freedom of speech and expression is something which is asked, which is mentioned in the Constitution as your fundamental right, we are giving you another fundamental right. We are inferring freedom of speech and expression to mean that this right to information, particularly of the voters' right to know the antecedents of the candidates contesting election, this is part of your fundamental right. This is part of your Article 19(1)(a). And if you have the right to say something, do you have the right not to say something? That means the corollary is, if you have the right to say something, you have the right to remain silent as well. Supreme Court said right to remain silent is also a fundamental right. Right to press. Right to press means you can't only express yourself. Can you express the views and thoughts of others? For example, a newspaper is publishing the views of Shashi Tharoor on Operation Sindoor, is publishing the views of Sonia Gandhi on Iran and Israel conflict, is presenting the views of Pratap Banu Mehta in Indian Express. Freedom of press is explicitly mentioned in the US Constitution, but not in Indian Constitution. One of the biggest assaults on the media was done during emergency, when censorship was imposed on the media. Not just censorship, pre-censorship as well. That means whatever the government allows, the media can publish only that. The newspapers can publish only that. And the biggest assault on the media came in the form of an assault on Indian Express, where even their editor, Kuldeep Nair, was arrested. When even Ramnath Goenka, who is the owner of Indian Express, he was subjected to mistreatment. Supreme Court said right to press is a fundamental right under Article 19(1)(a). Even if it is not mentioned in the Constitution explicitly, we are telling you, we are the final interpreters of the Constitution. You have the fundamental right to the freedom of press. Same organization, Association for Democratic Reforms, approached the Supreme Court again. And finally, this verdict was given in 2024. My lord, I have another question. What is the question? So last time we asked you, do I have the right to ask questions to candidates contesting elections? You said yes. Now this time, do we have the right to ask questions to political parties? How are they getting funding? Who is funding them? Because unless and until we know which political party is being funded by which entity, we may not be in a position to make an informed choice. What are you saying? Sir, I am an environmentalist. I believe in the protection of environment. And look at what is happening in Chile. Look at what is happening in Indonesia. Because we wanted to shift from internal combustion engines to EVs. The extraction of nickel, the extraction of cobalt, it is leading to destruction in these fragile ecosystems. I am against the use of fossil fuels. I'm against the use of coal. So what? Come to the point. Sir, what if there is a company which is polluting the environment and the same company is funding this political party X? I should know this. Because if I get to know, then I will not vote for this political party. I will vote for someone else. Because there is always quid pro quo. What is quid pro quo? Who called Gandhiji Mahatma?
Subhash Chandra Bose.
Sir,
Come on. You have discussed history and you got me
Rabindranath
to-
Tagore.
Rabindranath Tagore. And who called Tagore Gurudev?
Gandhi.
Mahatma
Vice
Gandhi.
versa, isn't it?
So
Gandhi
it is
sir.
like you confer title on me, I will confer title on you. Quid pro quo. Although it is not quid pro quo, but this is just to make it humorous. If my government, my political party gets the funding from Adani, why will Adani fund me? Because tomorrow when I will form the government, I will make policies which will favor the Adani business. That's quid pro quo. So if there is a company which is polluting the environment, and this company is funding this political party, I should know, because then this government will make policies which will go against environment, which will go against my principles, because I'm an environmentalist. But the government has started a scheme called electoral bonds. And this electoral bond scheme was such that this entire donation was anonymous. Even if there is a company which is donating money to a political party, but this donation is anonymous, that means nobody will get to know who is donating money to whom. How will I, as a voter, make an informed choice? My lord, previously you said that voters have the right to know the antecedents of the candidates contesting elections by asking these questions. This time you give us the right that we have the right to know who is funding these political parties. Supreme Court says, Ja Simran Ja, ji le apni zindagi. This is your fundamental right. This is Article 19, Clause 1, Clause A of the Constitution. Freedom of speech and expression. Say whatever you have to say. Express whatever you have to express, no matter which medium you use. And within freedom of speech and expression, those rights have been conferred on us, which originally were not part of the Constitution, and that is what we call inferred rights. But this freedom of speech and expression is not absolute. There are reasonable restrictions imposed on freedom of speech and expression. What are these reasonable restrictions? We will discuss after a break. So we will come back at 8:55. Okay, see you on the other side of the break. Now, Article 19(1)(a) gives all the citizens freedom of speech and expression. But that does not mean that this free speech is unrestricted. There are reasonable restrictions imposed on our free speech. First is on the grounds of sovereignty and integrity of India. Initially, and this may be relevant for your prelims examination, initially in 1950, there were 4 reasonable restrictions. Now in 2025, there are 8 reasonable restrictions. So 4 reasonable restrictions got added through constitutional amendment. And the first reasonable restriction is in the interests of sovereignty and integrity of India. What does that mean? In simple terms, if you have the freedom of speech and expression, you want to express yourself. Can you express yourself by making a map of India? But what if in this map, you do not show Aksai Chin as part of India? You do not show Pakistan occupied Kashmir as an integral part of India, which means you are expressing yourself by creating the copy of the map of India, but thereby you are against the sovereignty and integrity of India by excluding the legitimate Indian territories from the map of India. Would this be allowed? No. Why? Because this would violate a reasonable restriction imposed by the Constitution, which is sovereignty and integrity of India. That's reasonable restriction number 1. Number 2, security of the state. If you have freedom of speech and expression under Article 19(1)(a), which we have discussed, the Supreme Court has said, includes freedom of press. Right or wrong? Right. Now, what if this press is print media, for example, the Hindu? When Operation Sindoor was launched, in the initial hours, a tweet was posted by the handle of the Hindu, wherein it says that 3 Indian aircrafts have been shot down by the Pakistani Air Force. But immediately after that, this post was taken down. Why? Because it might endanger the security of the state. In other words, for example, there is a conflict between India and Pakistan. Now the media, for example, the Hindu, got access to what exactly Indian army is going to plan against Pakistan. Maybe the details of Operation Sindoor have got leaked, and Hindu is in the possession of the operational details of this operation, security operation. And can Hindu use its fundamental right, which is freedom of press, and reveal all the security details of this operation in its edition of the newspaper? No. Why? Because this is a reasonable restriction. Anything that you post, anything that you express, anything that you say, if it is going to endanger the security of the state, this is not protected under the Constitution. For example, there is, let's say, an encounter breaks out, something that we witnessed in 26/11 Mumbai attacks, when Pakistani terrorists, 10 in number, crossed India through the waters of Mumbai and then attacked the Taj or Trident and Oberoi and the Chhatrapati Shivaji terminal. All the details of this operation were broadcasted live. And later we realized that the terrorists who were being handled from across the border, these terrorists would get signals from across the border. Now do this, because we know what the Indian army is doing in these operations. Now you shift to the other room in the Taj Hotel. Why? Because entire operation was being broadcasted live. After that, rules were made by the government that whenever there is a security operation going on, you cannot live stream that security operation. Even if you have to broadcast some visuals from that operation, it must clearly say deferred live. Otherwise, what it will do? It will endanger the security forces in carrying out that operation. That is not your free speech. That is not protected by the Constitution, because in the interests of sovereignty and integrity of India, number one. Number two, in the interest of the security of the state, your freedom of speech and expression can be restricted. Third, friendly relations with foreign states. Originally, this was not a reasonable restriction. This reasonable restriction was added by the Constitution, First Constitutional Amendment Act, 1951. It is the responsibility of the Government of India to ensure that public opinion against a country which is our friend is also favorable. Why favorable? Because, for example, tomorrow, MBS. Who is MBS?
Mohammed bin Salman.
Mohammed bin Salman. He is the de facto ruler of Saudi Arabia, although a crown prince, but he is the de facto ruler of Saudi Arabia. And against this individual, there are serious charges of murder. Murder in the sense, there was one individual, Mr. Jamal Khashoggi. Have you heard of him? Anyone?
Yes, sir.
Who?
Press reporter.
Press
Press
reporter.
reporter
He was not a
assassinated.
reporter.
The journalist, something, he assassinated it.
Okay. Saudi national. He was writing for the Washington Post. He was an opinion writer. He would write columns for the Washington Post. Initially, he was close to Mohammed bin Salman. Later on, he became a critic of Mohammed bin Salman, and he would write critical arguments and articles against MBS. Then what happened? He went to Istanbul, Turkey, to renew his visa. And then he entered this Saudi embassy in Istanbul and never came out. Then we realized what happened. He is absconding, he's disappeared. Investigation was carried out, and this investigation revealed that if he entered this Saudi embassy in Istanbul, he came out as well, but in a bag where his body parts were stuffed, which means he was killed inside the Saudi embassy. And who ordered the assassination of Jamal Khashoggi? It was MBS. Now, MBS is a very powerful man as well. Look at what happened when Donald Trump visited Saudi Arabia recently. And Donald Trump decided that all the cases against the Syrian president, the new Syrian president, who was previously a United Nations Security Council designated terrorist because he was part of HTS. Now, this UN designated terrorist, US designated terrorist, is the head of the Syrian government. And why restrictions or sanctions against this individual were taken back on the request of Mohammed bin Salman. And Donald Trump, he's a transactional world leader. He said, because the prince asked me, I'm doing this. And prince said, wow, Habibi, you are best. Give me a hug. What if MBS visits India and they want to have good relations with India, maybe new investment in India? But in India, there are protesters who are protesting against MBS, calling him dictator, calling him killer, calling him a murderer. MBS will tell Mr. Modi, Habibi, what are you doing? I thought we will have good relations with each other, but your people hate me. And if they hate me, why should I have good relations with you? Any such protest against MBS, any such article critical of MBS can be taken down by the government. Why? Because this is not protected under your free speech. Now, you may think that this is a regressive provision. Why should Indians not criticize a foreign country or the leader, even if that's a friendly country? But the point is, this was done by a constitutional amendment in 1951, which means your freedom of speech and expression can be restricted in the interests of having good relations with foreign states, friendly relations with friendly countries. Third reasonable restriction. Fourth reasonable restriction is public order. And what is this public order? Ramesh Thapar was a communist. Leftist ideology, communist. He would import or buy a magazine which was published in Bombay called the Bombay Mirror. And he would buy this magazine, and this magazine would be distributed in Madras as well, which is the current day Tamil Nadu. But then the government of Madras decided to ban this magazine. Why? Because it had leftist ideology. Leftist ideology means Marxian ideology. Marxian ideology means revolution, even if the revolution is a bloody one, which is not acceptable to the state. Why would we allow people to revolt against the state? And ultimately what happened, this magazine was blocked and banned. Matter went to the Supreme Court. Ramesh Thapar approached the Supreme Court, my lord, if we have freedom of speech and expression, we have freedom of press as well. And there is this magazine which we wanted to read and transport into Madras, but the Madras government has banned this. Madras government was asked by the Supreme Court, come here. What are you doing? Sir, what? You are violating the freedom of speech and expression. Sir, when this magazine is brought into Madras, sir, there are problems, law and order problems. Then people start pelting stones. They start disturbing law and order. It is for the protection of law and order. It is to restore public order. It is to ensure public order that we are banning this magazine. Supreme Court came down heavily on the Madras government. How dare you do that? Is such a reasonable restriction mentioned in the Constitution? That in the interest of public order, you can restrict freedom of speech and expression of the citizens of this country? It is not mentioned. So this magazine should be allowed to be distributed in Madras as well. And then the government realized that this may be a recipe for disaster. Public order can be violated by certain free speeches. And we need to restrict those free speeches, that form of expression, if it violates public order. That is how Parliament got together, amended the Constitution, and added another ground, public order, as a reasonable restriction. Which means one by one, when we are studying freedom of speech and expression, there are reasonable restrictions as well. It seems that it's like the salary given to you, but Nirmala Tai taking 50% of that salary in the form of a tax. So this is CTC on paper, and this is the actual salary that you get in hand. And there is a massive mismatch between what is there on paper and the salary that you get in your hand. So Constitution on one hand gives you free speech, but the same Constitution one by one snatches this as well, imposes reasonable restrictions. And one such restriction is public order. Should free speech be restricted on the grounds of public order? Yes or no?
Sir, isn't public order a vague word?
Why is it vague? Public order means lack of absence of peace, tranquility that would violate
Sir,
public order.
sir,
How is it vague?
sir, for example, I say something that incites a religion, but I say it truthfully, and the government says that it is disturbing public order, and I
Why
cannot
do you
say
say
it.
something about a religion? Don't say.
No, sir. For example, about a political party. For example, we say something about Modi. Then there is a mob. It is incited to do violence, and the government will say that we cannot allow you to speak because it is destroying the public order.
I don't teach well, and students complain that sir is not teaching well. He is giving irrelevant examples, does not teach strictly according to the syllabus. And then there are my devout set of followers who lynch you. Should this be the ground to curtail your free speech?
No, sir.
Then,
It is duty of government to ensure the peace, sir.
right, then
Sir, that is what I'm saying, that government should not use this vague word like public order, because government is
Okay.
failing in their duty.
okay. Very good. And anyone else?
Yes, sir. Actually, this public order, it should be there, because what public order in general sense means an attempt to overthrow the state. Another question may be if there was real.
No, that can be against the security of the state. So that is covered separately. That can
Yes.
be under incitement to an offense or violence. That is covered separately. I'm specifically talking about public order. Public order in the sense, Sanjay Leela Bansali makes a movie, Padmavati, against, and which is treated as anti-Rajputs by certain sections in Rajasthan. And what happens to this producer? He is dependent on Friday. Because if this movie does not get released on Friday, it does not get favorable support on Friday, people are restricted from watching this movie on Friday, the producer will lose the business. What will happen to then those who are dependent upon their livelihood on this movie? And Sanjay
Yes, sir,
Leela Bansali
but-
decided to change the name of this movie from Padmavati to Padmavat.
Sir, but we have to be proportional. Like if it is hindering the income of some producer and a few give, or it is going to create a more violence, then it is more plausible to
Very
stay the
good. Then
film.
what will happen to my creative expressions? My creative freedom? Will it not lead to self-censorship? I am censoring myself. Why? I want to make this movie. I want to write the song. I want to write this book. But even if I am expressing myself creatively, it may offend somebody. Then my movie will be stalled on Friday. Then my producer will take a hit. I will remove these parts from the movie. I will not make such a movie. It will affect filmmakers. Then it is not Hindustan, it is Banistan, because everything gets banned. A book which was not acceptable to Muslims, Satanic Verses written by Salman Rushdie, got banned in India. A movie which was critical of emergency was banned during emergency. Kishore Kumar was banned from Doordarshan and All India Radio during emergency. Why? Because he spoke critically of the Prime Minister. Isn't that censorship? That violates, just because it is violating public order, your freedom of speech and expression can be restricted. But there are some good points, some bad points. For example, I decide to watch a movie. I go to a multiplex and I'm buying a caramelized popcorn, which has a different GST, or a salted popcorn, which comes under a different GST regime. Then I buy an inflated Pepsi as well. And with calmness, I'm watching this movie. Suddenly, I decide to play something naughty. and I say, cry, cry, fire, fire, fire. I'm crying, fire, fire, fire. There is no fire, but I'm crying fire. What happens? You won't even look here and there whether there is fire. You want to rush through the exit gate because you want to save yourself. What will happen? There will be stampede. People will die. Then the police will come to me. Come, gentlemen, we will take you to prison. We are going to arrest you. Why? Because through your actions, people have lost their lives. I will say, so what? I'm just expressing myself. I can say whatever I have to say. And even if I said fire, 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 there was nothing. Just on that basis, can you arrest me? No, this is my freedom of speech and expression. But it can't be, because through your action, you have violated public order. So your free speech has to be reasonable. It can't be unreasonable. So say whatever you have to say, but with some dignity, with some responsibility. Otherwise, you're violating public peace. India is a land of diversity. You will say something to provoke a particular religion. Obviously, the followers of that religion will get offended, and then there will be protests. There will be violation of public order. Public peace, tranquility will be under assault. This is where state will have the right to impose reasonable restrictions on your free speech. Because whatever you say should not lead to the violation of public order, disturbance of public order. But on the other hand, isn't it the responsibility of the state to maintain public order? Then why do we have police? Even if I have said something about this caste or about this religion, but it is not untrue, it is not false, it is truthful, it is for the police to give protection to me. Yes, you can protest without threatening those who want to watch this movie. In a case known as K.A. Abbas, Supreme Court said filmmakers have the right to even project their movie, get their movies released, because that is part of your creative expressions under Article 19(1)(a). But it is this clause of public order which is being misused by the state governments. They are not giving support or security to the filmmakers or the artists. They are withdrawing from their responsibility of maintaining peace and security in the state. And then what it leads to? It leads to heckler's veto. All I have to do is arrange a band of 10-50 people, start throwing stones at a public place, at a mall, at a restaurant, or at a movie theater, and then stop the release of this movie, stop the release of this book, stop the release of this painting. Which means then hecklers in India will get a veto, and the state is unable to restore public order, maintain public order. This is your responsibility. If you're not happy with this movie, don't watch it. Or write a critical review of my movie. But you can't stop me from releasing this movie, or stop others from watching this movie. If you don't like my book, instead of burning it or banning it, stop reading it or write a critical review. Public order has been misused as a ground by the state, where the state is withdrawing from its responsibility of ensuring peace in the society. And what it leads to? It leads to self-censorship. Filmmakers would be hesitant in making a movie which is critical of the government or critical of a particular group. Then what will happen to my creative expressions? Shouldn't these creative people be allowed to express their creativity in whichever way they want? So there are some arguments in favor, arguments against. But public order is a reasonable restriction on your freedom of speech and expression. Fifth one, decency or morality. If you have the freedom of speech and expression, can you write a novel which is pornographic in content? Can you make movies which are XXX rated in India, which goes against morality or decency of the society? So in the name of morality or decency, which the Supreme Court has said, decency means lack of obscenity. Your content should not be obscene. Your creative expression should not be obscene, because the state has the responsibility of protecting the morals of the people. Because just like Constitution gives you a political identity, it also gives you a moral identity. And this moral identity, the Constitution, the state has to protect. This is where there is a problem. Problem in the sense, what is moral to me may be immoral to you. And what is immoral to you may be moral to me. Because all this discussion on morality or decency or obscenity, it is subjective. Somebody wearing a hijab may be moral, and somebody wearing a jeans pant is immoral. Who decides this morality? Who is the custodian of morality? You, me, who? Tell me. W.H. Lawrence, he wrote a book, a novel called Lady Chatterley's Lover. And this book was to be imported in India, but it was banned in India. Why banned? Because the content of this novel was obscene. Similarly, Lolita, written by Vladimir Nabokov, it was also banned in India. Why? Because it was obscene. Why was it obscene? Because Lolita displayed the protagonist is having sexual relationship with a minor girl, which is not acceptable to our morality. Similarly, in Lady Chatterley's Lover, the man is allowing his wife to have sexual relationship with others. And those sexual relationship with others are graphically displayed in this novel. And when this novel was brought to India, it was banned. Even then, one distributor of Maharashtra, Ranjit D. Udeshi, he was arrested, charged, because you are violating the laws of obscenity. Because although you are expressing yourself, freedom of press, freedom of circulation, freedom of distribution is your fundamental right. You can circulate any book, you can distribute any book, you can publish any book, you can write any book, but as long as it is moral, it is decent, it is not obscene. Since this novel is obscene, you are under arrest. There was a demand made by the members of press as well as some writers. They wrote a letter to the then finance minister, Morarji Desai, that please ban Lolita because this novel is promoting obscenity. But finally, when the matter reached Pandit Nehru was a liberal. Pandit Nehru said, no, don't ban this novel, let it continue. But Lady Chatterley's Lover was banned. And here the Supreme Court imposes a test called Hicklin test. What is Hicklin test? Let's say, for example, this is a book. And in this novel, there are 5 chapters. Assume that 4.5 chapters are decent, are moral, do not have any obscene content. But only a part of this content is obscene. Hicklin test prescribes that the entire book should be banned. Normally here, the doctrine of severability should come into the picture, which means if the entire book is not obscene, a part of this book is obscene, you remove that portion and let others read the remaining part of the book. But Hicklin test says, even if a part of this book is obscene, ban the entire book. Even if a part of this movie is obscene, ban the entire movie. This is Hicklin test. But over a period of time, Supreme Court has discarded Hicklin test. Said, no, even if a part of this novel is obscene, but we have to look at the larger messaging of this novel. If the larger messaging is not obscene, we will not have to ban this movie, not ban this book, let it continue. And morality is not only subjective, it is based on time. It is time specific. There was a time when a romantic scene between two actors was displayed in the movies by the kissing of two flowers. But over a period of time, we have seen full-blown kissing scenes, romantic scenes, erotic scenes in the movies as well. So what is obscenity? What is immorality? What is decency? All these are subjective terms and keep on changing according to the time. Same goes with Ranveer Allahabadiya. Have you heard of Ranveer Allahabadiya?
Yes, sir, YouTuber.
Yes, sir.
Bare biceps, podcaster. He was participating on a program called India Got Latent of another stand-up comedian, Samir Raina. And in this program, he made some remarks. And these remarks were considered obscene. Do you know how many amongst you know what was the remark made by Ranveer Allahabadiya?
Yes, sir.
One,
No,
two, three, four.
no, sir. No, sir.
11 out of 73. Good, then you are good students. You are away from this controversy, away from YouTube. Good job. Okay. Should I say that or not say? He said something obscene. And it was not obscene per se. It was horrible. It was preposterous. It was obnoxious. It wasn't even comic. It wasn't even humorous. What he said, you're all adults. He asked a contestant, would you prefer seeing your father and mother having sex all the time, or would you jump in once and end it forever? Horribly. It doesn't make any sense. It is not even comedy. It is not even obscene. What is obscenity? Supreme Court has said any content, and listen to me carefully, this is why it is important. Any content, if it generates any movie, any song, any literature, any creative expression, any painting, if it generates an element of lust in you, it is obscene because it corrupts your mind. But when you read the statement or when you heard the statement of Ranveer Allahabadiya, did it generate an element of lust in you or disgust in you? It was disgusting. So it was not even lustful. Yet case was filed against him in different police stations in this country, in Mumbai, in Assam, various other parts. Then he approached the Supreme Court with a simple plea, with a simple request that, my lord, please club all FIRs. Please club all the FIRs. Club in one place, in one jurisdiction, so that I don't have to travel to Assam, to Gujarat, to Mumbai, to Delhi to fight the cases filed on the same issue. Please club all these FIRs so that I can defend myself in one jurisdiction. This is a legitimate plea and should have been granted. Instead, what Supreme Court said? Supreme Court said, Ranveer Allahabadiya, you have a perverted mind. You have a perverted mind. You should not have done this. From now onwards, no podcasts. Surrender your passport. And we will still not club all the FIRs together. This was judiciary at its worst. Why? with no love lost for Ranveer Allahabadiya, he made a distasteful comment, which was not even comic, but it was not obscene. It was distasteful, horrible. But what is the job of the Supreme Court in imposing censorship? Supreme Court is censoring Allahabadiya that no more podcasts. And as if you are a thief or a criminal and you will run away from this country, you will have to surrender your passport. This is like in Dark Knight when Heath Ledger is asking everyone else, why so serious? Right? You should smile just like me. Why so serious? It's like Supreme Court. We should tell Supreme Court, why are you so serious? You look at the case dispassionately without getting too emotional. Club all the FIRs together and let the proceedings take place. Why do you have to say that you have a perverted mind? You will put all the mothers, daughters, and sons into shame. This is not the job of the judiciary. Job of the judiciary is if a government would have imposed censorship, would have confiscated your passport, the job of the judiciary was to ensure that it does not happen, because the government can't be arbitrary, unreasonable. But Supreme Court has said, if there is a comment or a creative expression which generates an element of lust in you, that is obscene. Otherwise, it is not obscene. But there is a problem with this definition as well. What if you're old and no matter what you see, there is no element of lust which generates in your mind? So what is lustful for an 18-year-old may not be lustful for a 70-year-old man. Because this Lady Chatterley's lover, when it was to be banned in India, the copy of this Lady Chatterley's lover was given to all the judges of the Supreme Court who were hearing this case. Once a judge, he said, it does not generate an element of lust in me. Perhaps I'm growing old. This is what Supreme Court, US Supreme Court judge also said. Obscenity cannot be defined like this, because what is obscene to you, what generates lustful thinking in you, may not generate the same feelings in me because I may be growing old. So the problem is even with the definition of obscenity. But be that as it may, if your freedom of speech and expression is your fundamental right, it is not unrestricted. It is not an absolute fundamental right. It comes under reasonable restrictions. One is in the interest of the sovereignty and integrity of India. Second, security of the state, friendly relations with foreign states, public order, morality or decency. And sixth reasonable restriction is contempt of court. What is contempt of court? We say Supreme Court is final. Not because it is right, but Supreme Court is right because it is final. If you have got siblings and you would fight with each other when you were in your childhood, then who is right, who is wrong? You would go to a grandfather or a grandmother. And whatever grandmother, grandfather says, that is the right picture. So whether your sister is right or you are right, whether your brother is right or you are right, that will be decided by the elder. And since you respect the elder, whatever he or she says, you have to abide by it. Similarly, in India, if there is a dispute, what do we tell each other? I will see you in court. Court may make mistakes. Court may err here and there. But even then, we have to respect the court. Why? Because it is final. It is the final court of appeal. Because after Supreme Court, where do we go? Then there will be a situation where this dispute will never come to an end. Right? Supreme Court and its decisions are acceptable because of its moral authority. Because of its legal authority as well. You will never hear somebody saying we will not accept the decisions of the court. You can't do that because it has legal authority, moral authority to impose its decisions, to enforce its decisions. That is why on any sensitive matter, if there is a dispute, all the parties to that dispute, they say, we will abide by the court decision. Ayodhya, the biggest ever dispute in India. All the parties said, whatever Supreme Court decides, we will accept it. And they accepted it. On Sambhal, if there is a dispute, all parties say, we will abide by the court directions. Because court has the legal authority, the moral authority. But what if there are people who are the citizens of India? They will use their free speech under Article 19(1)(a) and cast aspersions on the Supreme Court. Scandalize Supreme Court. Scandalize in the sense, this Supreme Court has given judgment in Ayodhya case because all these judges are casteist Hindus. By saying this, what am I trying to say? I'm trying to sow the seeds of mistrust and distrust in the minds of the people. Then tomorrow, will you accept the Supreme Court? No. Why? Because I'm using my free speech to plant seeds of discord in your mind. Or this judge has given this judgment because this judge has taken a bribe. Then it will give a sense that Supreme Court is working on bribe. Then how will I trust Supreme Court? This Supreme Court judge has given this verdict because this Supreme Court judge has got some benefit from the executive. You are questioning the independence of judiciary. Then how will others trust the courts, trust the judiciary? That is why, to ensure the moral authority, the legal authority of the courts in this country, judiciary in this country, judiciary has been given the power that you can punish those who are committing contempt of you. You don't have unrestricted free speech. Because through this free speech, if you are bringing Supreme Court or courts into disrepute, we are going to punish you. And this contempt is of two types. First is civil contempt. Only thing that Constitution talks about is that your freedom of speech and expression can be restricted on the grounds of contempt of court. But what is this contempt? It has not been defined. For that, we have a law called Contempt of Courts Act passed by the Parliament in 1971. And it is this law which defines what is a contempt. And it defines contempt into two. Either it is a civil contempt or a criminal contempt. What is a civil contempt? For example, Supreme Court gave the verdict in Ayodhya case that this 2.77 acres of land, disputed land, belongs to Lord Ram, and a Ram temple can be constructed on this disputed site. What if the Muslim side say, we will not accept this verdict? So you are willfully, deliberately disobeying the court order. This is contempt and civil contempt. Or you are asking the people, let's go to Ayodhya and let's stop the construction of the Ram temple. So you are obstructing the directions of the court. This is civil contempt. Or what you're trying to do. If the Supreme Court ordered that 5 acres of land at a prominent place in Ayodhya should be given to Muslims, where if they want, they can construct a mosque. What if the UP government says, we will not accept this verdict? We will only construct Ram temple. We will not give 5 acres of land at Ayodhya to Muslims. You are willfully, deliberately disobeying the court order. And if you do that, that is civil contempt. But criminal contempt is something which is dangerous. You scandalize the court. You interfere with the directions of the court. How? I'll give you an example. Here is an individual. His name is Prashant Bhushan. Have you heard of him?
Yes, sir. He paid 1 rupee for contempt of court. I
He
think last
takes or pays?
paid.
Okay. Prashant Bhushan is a known activist, is a lawyer of the Supreme Court. When the nation was under a lockdown during COVID, he tweets, And what he tweets, he says the then Chief Justice of India, Sharad Arvind Bobde, he is riding a Harley Davidson bike. So what? But without mask. So what? At Nagpur. So what? And this bike belongs to a BJP leader. So what? At a time when he has locked the doors of Supreme Court. What is freedom of speech and expression? Say whatever you have to say. He is saying whatever he has to say. But is this an absolute fundamental right? No, because there are reasonable restrictions. If you commit contempt of court, this free speech is not protected. Prashant Bhushan was asked, come here. What are you alleging? Are you alleging that Supreme Court Chief Justice is riding a Harley Davidson bike? But can't you see he's not riding? The bike is on the stand. So you're lying, number one. But then through this lying, you are casting aspersions. You are sowing seeds of mistrust in the minds of the people. You are saying he's riding a bike in Nagpur. Are you alleging because Nagpur is the headquarter of the RSS? And this bike belongs to a BJP leader, which means there is no independence of judiciary. And you are saying it at a time when we have locked the doors of the Supreme Court. We have not locked the doors of the Supreme Court. The doors of the Supreme Court are open because we are hearing cases virtually. Even if the court is closed, that does not mean justice has stopped. We are hearing cases virtually. So you are trying to scandalize the Supreme Court or the Supreme Court judges, and this is contempt. And in contempt of court, maximum punishment which can be given is 6 months. But the Attorney General, Mr. K.K. Venugopal, he said, yes, this is contempt, but dear Supreme Court, please be lenient on Prashant Bhushan because he has done a lot of good things for the society as well. And we request you, punish him for contempt of court, but impose a fine of ₹1. Prashant Bhushan was convicted. He had to pay a fine of ₹1, but this is criminal contempt of the court. Now, can a judge be convicted for contempt? Judge may convict others for contempt, but can a judge himself be convicted for contempt? We have the beautiful example or a disturbing example of Justice Karnan. Justice Karnan, he was the judge of the Madras High Court. Then he was transferred to the Calcutta High Court. And he wrote a letter to Prime Minister Modi alleging that there is corruption in judiciary. And I'm giving you the list of the judges who are corrupt. Now, Supreme Court met. 9 judges of the Supreme Court met. What is this Justice Karnan doing? He's writing a letter to the Prime Minister alleging there is corruption in judiciary. He should have written a letter to the Chief Justice of India. He is demeaning the judges. He is defaming the judges. He's basically scandalizing the judiciary as an institution. He should be punished for contempt. 9 judges issued an order to the judge, Justice Karnan, that you come before the Supreme Court. This judge, Justice Karnan, he is issuing arrest orders of these 9 judges. You're asking me to come to Delhi to explain my position? I am ordering the police arrest these 9 judges. The judges said, now this is enough. The judges convicted Justice Karnan of contempt of court, and he had to spend 6 months in jail for committing contempt of court. Now comes the interesting point. Now comes the most important point. How do we balance free and fair criticism of judgments or judges and content. Does that mean we can't say anything against the judgment given by the court? Even if the judgment is blatantly wrong, will any fair, honest criticism of the Supreme Court judgments or judges be declared as contempt, be viewed as contempt? This is where there was serious misuse of this law. And finally, in 2006, the Parliament amended this Contempt of Courts Act of 1971 and made two important changes. Two important changes. Number one, no criminal sanction can be given for contempt unless the court is satisfied that the contempt is such that it genuinely interferes with the justice, or the court permits truth as a valid defense if this truth is given in larger public interest, in good faith, bona fide. What does that mean? Let me explain with an example. The year was 2013. Two judges of the Supreme Court, Justice P. Sathasivam, who later on became the Chief Justice of India, later on was appointed as the Governor of Kerala, Justice Sathasivam and Justice Khalifullah, they were hearing a case. And the case was related to Maninder Singh. Who was Maninder Singh? Previously, Maninder Singh, what he had done, he had raped his daughter. When he had raped his daughter, matter went to the Punjab High Court. Punjab High Court said, no, this is not the rarest of the rare case. We will give him life imprisonment. Or first, Punjab High Court said, we will give him death sentence because this is the rarest of the rare case. Maninder Singh approached the Supreme Court. Supreme Court said, no, this is not the rarest of the rare case. We will give him life imprisonment. Because in death penalty cases, there is a doctrine called rarest of rare, and which we will discuss in Article 21. Unless and until it is a rare case, only in exceptional circumstances, death sentence should be awarded. Otherwise, life imprisonment should be given. Death should be given in extreme circumstances. Maninder Singh raped his daughter. High Court said, give him death sentence. Supreme Court said, no, no death sentence. This is not the rarest of the rare case. We will give him life imprisonment. Okay. He was serving life imprisonment and Maninder Singh was then released on parole. Parole is, briefly, you are released, but then you have to come back to the jail. So he was released on parole. While he was released on parole, he killed the daughter he had raped and he killed his wife as well. Matter went to the Punjab High Court again. Punjab High Court said, now this is clearly the rarest of the rare case. So you're raping your daughter, then you're serving life imprisonment, then you're released on parole, then you kill the daughter as well as the wife. This is rarest of the rare case, death sentence. Matter went to the Supreme Court on an appeal in 2013. These two judges, Justice Khalifullah, Justice Sathasivam, they say, Maninder Singh may be a threat to his family, but he's not a threat to society. When he's not a threat to the society, no rarest of the rare case can be made out. Life imprisonment should be given to him, not the death sentence. Okay, fair enough. 2 weeks later, same judge is hearing another case. And this time, a 7-year-old boy is kidnapped. 7-year-old boy is kidnapped and then killed. The accused was given death sentence by the High Court. On an appeal, this matter reached the Supreme Court. Same judges who said Maninder Singh is not a threat to the society, he may be a threat to family. So for Maninder Singh, no death sentence, life imprisonment. Same judges are hearing the case of 7-year-old boy who has been kidnapped and then killed. Supreme Court said this is rarest of the rare case. Supreme Court gave reason as well. These judges gave reason as well. Supreme Court said, imagine the plight of the family which has lost its only male child. And this male child would have carried forward the family lineage as if this is the last generation of the dinosaurs, and after that the dinosaurs will become extinct. These judges came under severe criticism on the grounds of patriarchy. There is no other way to understand this judgment other than patriarchy. The value of a woman and her daughter who was raped, there is no value. But there is a value for the 7-year-old boy. Both are valuable. But if you had to choose, if I had to choose, which is the rarest of the rare case, I would take Moninder Singh's case. This is the rarest of the rare case. Stringent punishment should be given. Death. Articles and articles were written, and against some writers, contempt of court proceedings were initiated. Supreme Court said, you are committing contempt. What is this? But then finally, better sense prevailed, and Supreme Court did not punish. Supreme Court did not punish those writers who criticized the Supreme Court. Why? Because whatever they said was truth. They did not attribute motives to the judges. They said what it is. It was mentioned in the judgment that what will happen to the family which has lost its own male child, only male child, who would have carried forward the family lineage. Because truth was spoken in this case. And this truth was told in public interest. It was not for the personal interest of these writers. It was for the larger public interest. Look what is happening in the judiciary. Let's expose these patriarchal judges. So you can criticize the Supreme Court. You can criticize Supreme Court judgments as well, but only on the grounds of facts, on the basis of truth, without interfering with the judgment. Interfering with the judgment in the sense, you may not like the Supreme Court judgment in Ayodhya case, but you can't say, let's go to Ayodhya and stop the construction of the Ram temple. That you can't do, because then you are interfering with the justice. But you can criticize. I don't agree with this judgment. I don't agree with EWS judgment. But you can't say, let's block all those who are getting EWS reservation. You can't interfere with the administration of justice. You can criticize the Supreme Court based on facts. You can point out the defects in this judgment. And that is where you have freedom of speech. But you don't interfere with the justice. You don't attribute personal motives to the judges, that this judge has said something because of his caste or his religion or his close association with the government. Arundhati Roy once said that judiciary in India is an elitist, corporate Hindu judiciary, and for that contempt of court proceedings were initiated against her. That may be stretching you too far, because then you're sowing the seeds of mistrust and distrust in the minds of the public. And then the public may not trust the judiciary. What is the difference between defamation and criticizing? Very good. This is the 7th reasonable restriction. Sarmad sir does not teach well criticism. Sarmad sir is corrupt defamation, because I'm not. Even if I am, but you are saying this and there is no public interest which is served. What is the public interest served by you saying that I'm corrupt? That is defamation. Because if you have freedom of speech and expression, I also have a right. I also have a fundamental right, which is right to my reputation. Criticize me without defaming. And defamation is broadly divided into two. It can be libel, it can be slander. If through your words you're defaming me, it's slander. If through your articles, written format, you are defaming me, it's libel. For example, again, I'm linking it with history because history is something that you have covered recently. What was the reason of the failure of the Home Rule League, Home Rule movement?
Because
One important reason.
they were divided among themselves, that
And
Tilak
my dear,
and
common sense says when I'm asking a question, it has something to do with the topic that we are discussing right now.
The people did
One
not
reason.
support any peasant being a white woman.
Sir, the home rule movement thinks that we are in a minority in Is it right?
I'm not asking general causes of the failure. I'm asking something related to this slide. Home rule movement lost its steam because of some developments. And what were those developments? Tilak was not here. Tilak went to London to fight a libel case against a particular journalist. Have you read that? Okay. So you have freedom of speech and expression, but this is not absolute. It comes under reasonable restrictions. And reasonable restrictions are sovereignty and integrity of India, security of the state, friendly relations with foreign states, public order, contempt of court, defamation, morality or decency. And the last reasonable restriction is incitement to an offense. Rahul, take out a weapon and let's kill Anshul. I'm inciting you for an offense, but I'm exercising my free speech. This is not allowed. This is a reasonable restriction. These are 8 grounds on the basis of which your freedom of speech and expression can be restricted. Then what about sedition? Section 124, capital A of Indian Penal Code. Now, we don't have sedition. There is some another clause in Bharatiya Nyaya Sanhita, which we will discuss. But first, let's briefly discuss sedition. Sedition was part of Indian Penal Code, right or wrong? Right?
Yes,
Wake
sir.
up, guys. Right?
Yes, sir.
Yes, sir.
Yes, sir.
Right. Indian Penal Code was implemented in 1860. Right?
Yes, sir. Very
Right?
much.
Yes, sir. Yes, sir. Due to
Right.
Vavi Vadullah movement.
But this section 124 capital A, it got added in 1870. It was not originally part of IPC in 1860. That is why capital A, it was done through an amendment. Why was it not part of 1860 Indian Penal Code? Why was it added later? Something you might have read in history.
Vavi Vadullah movement in 1864.
It is because of that reason it got added, that I know. But why was it missed? Why was it not added in 1860? Because Wahhabullah movement was there in 1860s as well. There's only
Because revolt of 1857. So after that,
No, no.
British were
No, it is because it was missed. They somehow missed adding it to Indian Penal Code, although it was part of the Indian Penal Code draft, but they somehow missed it. But what is this Indian Penal Code, section 124, capital A? Whosoever, by words, either spoken or otherwise, that means either written or otherwise, if you are promoting disaffection against the government established by law. So this is not disaffection against the nation. This is disaffection against the government established by law. You will be charged with sedition, for which you may be given life imprisonment, for which you may be given 3 years imprisonment, for which fine may be added. This is sedition. But why was this provision added in the Indian Penal Code?
To
To
legitimize the government.
prevent the nationalist feelings from getting developed. Because initially, if you will realize, what was the growth of the Indian national movement? First, we had to tell people that you are a colony. So you have to awaken the nation. Wake up, guys. We are not free. We are a colony. Wake up. This is not our government. This is an alien government. Through this, how can you teach people? By maybe Nukkad Sabhas, by printing pamphlets, by plays,
Poetry.
by songs, by articles. That is why majority of the members of the initial Congress, they were either journalists or they were lawyers, because they realized it. And now we have to teach it to others, tell it to others, convey to others. But when you convey to people, what are you doing? You are promoting disaffection against the government. And this British government said will not be tolerated, because then you will be guilty of sedition. And one poor man who was frequently arrested under sedition was
Tilak.
Tilak. First time he was arrested was on what grounds? Modern history, man. First time Tilak was arrested was on what grounds? What was the case? Guys, I come here with passion. If you will demotivate me, then hello?
AMT Jackson case.
What's
No, no, no,
AMT?
no, no.
Sir, I think for publishing his newspaper Kesari. So under that there is
But
one
what
article.
exactly?
One
What
article which
yes,
is
you're right.
against Britishers.
He was obviously you cannot make it more vague than that.
Yes.
He said something against Britishers, and that is why he was arrested for sedition. He would publish two newspapers. One was Kesari, the other was Maratha. Right? Kesari was in which language?
Marathi.
And Maratha was in which language?
Gujarati.
Gujarati. English. Okay. Such questions can be asked in your exam. So please be clear about that. Be that as it may, there was plague in Pune. And the manner in which the government handled this plague, it was not acceptable to people. People were stripped naked, and Rand brothers, who were responsible of managing it, they were killed. Rand was killed by Chapekar brothers, and then a poem was published in Kesari, in which it was displayed how Shivaji Maharaj killed Afzal Khan. It was basically promoting the valor of Shivaji Maharaj, how he killed Afzal Khan with his sword. This was viewed by British as if you are supporting the killing of Rand by the Chapekar brothers. Because on one hand, there is Afzal Khan being killed. So you are equating Afzal Khan with Rand, Shivaji with the Chapekar brothers. You are promoting disaffection against the government established by law, which is sedition. Tilak was asked, come here. Judge Strachey was the judge. Tilak was asked, what is this? He said, I don't promote disaffection against the government. Judge said, yes, you're right. You may not be promoting disaffection against the government, but in your eyes, we don't see affection either. It is this absence of affection in your eyes which is seditious. Send him to imprisonment for 6 years. Then again later, he was arrested again for sedition. But then came a time when Mahatma Gandhi was arrested for sedition. Tilak, previously in 2 instances, he pleaded not guilty. So when you are accused of a crime, the judge will ask you, are you pleading guilty or innocent? I plead innocent, I'm not guilty. When Gandhiji was asked, what is your take? Are you guilty of sedition or not? Gandhiji said, I am guilty of sedition because it is my solemn right to promote disaffection against the government, which is anti-people. And then Gandhiji was also arrested under sedition, but then he was released quickly because after all, he was Gandhiji. But the point is, this section was primarily used to do what? To curb nationalist feelings from getting developed. Should our free speech be restricted on the grounds that don't promote disaffection against the government established by law? This was a matter of debate in the Constituent Assembly. Constituent Assembly had to debate whether sedition can be a reasonable restriction on your free speech, and Constituent Assembly decided no. Now we are a free government, and people should have the right to criticize the government. People should have the right to promote disaffection against the government as well. So this is part of your free speech. But don't incite people to violence. Do it peacefully. Promote disaffection, because unless and until I promote disaffection against the BJP government, how can people vote for me? This is important for political democracy. This is important for political education. And that is why the members of the Constituent Assembly said sedition should not be the reasonable restriction. Fast forward, we move to 1962. Kedarnath Singh case. What was not provided by the, look at the irony. This case is being celebrated in India, but there is a huge criticism which is often overlooked. What is the criticism? In Kedarnath Singh case, sedition appeared from the back door. Because till this judgment, sedition is not a reasonable restriction on your free speech. Now, in Kedarnath Singh case, Supreme Court upheld the validity of Section 124 capital A. Supreme Court said this is constitutional. But promote whatever you have to promote. Advocate whatever you have to advocate. Don't incite people to violence. So if you are doing something using your free speech, you're promoting disaffection against the government established by law. Do that. But don't incite violence against the state, against the government. And this was meant to prevent the misuse of sedition. So this judgment has been supported, praised, because this has limited the scope of sedition. Now, sedition cannot be invoked when somebody is honestly criticizing the government. But not many people realize that till this judgment, Section 124 was not a restriction on your free speech. It was made into a restriction by the Kedarnath Singh judgment. To understand this fully, Khalistani movement started in Punjab, which we will discuss in international relations briefly, but in internal security in detail. Khalistani movement, where the Sikhs or some sections of the Sikhs wanted a separate state of Khalistan for the Sikhs, separate country. And we saw the role played by, he is known as Sant Jarnail Singh Brindawale. Right? His supporter right now is the member of the parliament, Amritpal Singh. It is argued that Bhindrawale was roped in by Indira Gandhi to defeat the Akalis. So Akali Dal, which was a strong regional political party, they had a strong support in Punjab to weaken them, create a parallel political figure in the form of Bhindrawale, so that Akali Dal, they lose support and Congress is in a position to gain support in Punjab. But it backfired on Indira Gandhi because Bhindrawale now became a rogue. And he started amassing weapons, militants, and they wanted to wage a war so that Khalistan emerges from Punjab. And that's how they were stationed inside the Golden Temple in Amritsar. And that's how, in a historic decision or a historic blunder, depends upon how you look at it, Operation Blue Star was launched by Indian Army, and that's how Bhindrawale was killed. And there was a massive destruction of the Akhal Takht as well in the Golden Temple, which is considered to be a sad, sad story in India's post-independence struggles. But be that as it may, after Bhindrawale was killed, after Golden Temple got destroyed, and then Indira Gandhi was assassinated by her bodyguard, who happened to be a Sikh. And then there was anti-Sikh riots in Delhi, in various parts of the country, more specifically in Delhi, where it is argued that Amitabh Bachchan also gave an inflammatory speech. Rajiv Gandhi said something. Rajiv Gandhi was asked, there is massacre of Sikhs happening in Delhi. What is your take? He said, when a big tree falls, the earth under it shakes. So the big tree was Indira Gandhi. When she is killed, the earth will shake. There will be some Sikhs who will be killed. And that is why we call it anti-Sikh pogrom, where the state is involved, state institutions are involved in killing minorities. And when this Khalistani uprising, it got fuel in Punjab, slogans were raised. Raj Karega Khalsa, Khalistan Zindabad. And Balwant Singh and others, they were arrested. Matter went to the court because they were arrested on sedition. Because can you promote disaffection against the government? You can't do that. That is sedition. So they were arrested under sedition. Supreme Court set them free. Supreme Court said slogans cannot destabilize the country. No matter how inflammatory these slogans are, you can't. Unless and until you are advocating for violence. So Raj Karega Khalsa, Khalistan Zindabad makes no sense whatsoever. It is not promoting disaffection against the government. Unless and until you ask people to raise arms and overthrow the government of India and then establish Khalistan, that is calling for violence and that is sedition. In Shreya's single case, which was on section 66 capital A, Supreme Court explained what is this speech. For the first time, Supreme Court said, in this speech, advocate whatever you want to advocate. Propagate whatever you want to propagate. But don't incite people to violence. If you incite people to violence, it is sedition. Then slogans were raised in Jawaharlal Nehru University, JNU in Delhi. Kashmir ki azadi tak jang rahegi. Bharat ki barbadi tak jang rahegi. Till Kashmir is liberated, we will fight. Till India is destroyed, we will fight. And Kanhaiya Kumar and others, they were arrested for sedition. Some people said, how is this sedition? Because in Balwant Singh case, Supreme Court has clearly said, slogans, no matter how unpalatable they are, unless and until they are inciting people to violence, it is not sedition. And then we saw other cases. Other cases, for example, there was a journalist. This journalist posted on his YouTube channel when the country was in a lockdown, and in the lockdown, millions of people, migrants, started walking back on bare foot from cities back to the villages. And this journalist said, if the government is unable to provide them shelter and food, there will be riots in India. And this journalist, FIR was filed against him in Himachal Pradesh, and he was booked under sedition. Then there was a filmmaker from Lakshadweep. This filmmaker said that the administrator of Lakshadweep has deliberately tweaked, softened the anti-quarantine norms in Lakshadweep, and because of that, center is imposing a bio-war on the people of the Union Territory of Lakshadweep. Because previously there were no COVID cases. But when the anti-quarantine norms were relaxed, people came to Lakshadweep for tourism purposes, and with them brought the virus, COVID-19 virus. And this is nothing but the bio-war imposed by the center on the citizens of this Union Territory of Lakshadweep. And this filmmaker was booked under sedition. Then on a TV channel, one member belonging to the YSR Congress, he criticized his own government's handling of COVID. What happened to this person? He was booked for sedition, just for criticizing the government. And the bizarre thing was, those journalists who interviewed him, they were also booked for sedition. So we saw misuse of sedition laws. Mere criticism of the government, you are sedition. You are committing sedition. You are booked under sedition. And in the sedition, the process becomes the punishment. Because it will take you years to prove your innocence. But in those years, you will be languishing behind the bars. Finally, Supreme Court said, no more cases. The name of the journalist is Vinod Dua. Finally, the Supreme Court said no more cases. No more cases in the sense, we will have to revisit sedition. In the light of the misuse of this law, we have to see whether this law is constitutional or not. Till that case, till that time, unless and until we decide, no more arrests under sedition, and all the cases of sedition will be paused. That means the cases against this filmmaker, against Vinod Dua, who is now dead, against Kanhaiya Kumar and others, paused. And the government said, don't worry, we will not have sedition now. Because Indian Penal Code will now be replaced with Bharatiya Nyaya Sanhita. And in Bharatiya Nyaya Sanhita, we will have no sedition. Instead, we will have section 152, which is like a brother or a sister of sedition law. Look at the wording, more or less similar, but look at the wording. Whoever, purposely or knowingly, by words either spoken or written, or by signs or by visible representation, or by electronic communication, whatever, if you excite secession or armed rebellion, or encourage feelings of separatist activities, where you're endangering sovereignty, unity, and integrity of India, that means previously it was Rajdroh. That means offense against the government. That was sedition. Now it is not against the government. It is Deshdroh. If you are promoting disaffection against the nation, if you want to separate a state from the Union of India, if you want to promote a feeling of secessionism, Tamil Nadu should come out of the Union of India. Kashmir should come out of the Union of India. Khalistan should be established. Sikhs should revolt to establish Khalistan. If you do that, this comes under section 152. And this time the law is not vaguely defined. It is defined beautifully. Because we are saying, if you are endangering sovereignty by armed rebellion, which means if you're taking up arms, if there is no section 152, how can we solve the problems of Maoism, Naxalism in India? Because they are also advocating a separate country. They are also advocating that the central rule should be abolished. And for that, we will wage war against the country. Armed rebellion. So this section 152 is required. And it is a better improvement than the sedition law. Because in sedition, it was a Rajdroh. That means offense against this government. Now it is Deshdroh, offense against the nation. But even then, we have seen visible misuse of this law. Visible misuse of this law, how? Any recent example? Anyone? Read newspapers, man. Any recent example here? Wake up.
Sir,
Oh,
could the, I don't know, I'm just quoting for what I've seen. Could the
Hmm.
Republic TV Arnab Goswami's recent Karnataka case be taken as a misuse?
What is that case?
I have seen that he was fighting a case in Karnataka High Court.
But then he was acquitted. The case was stopped against him. That is
Yeah.
not section 152. What is section 152? Head of Political Science Department of the Ashoka University, Professor Mahmoodabad. What he said? Operation Sindoor has been launched by the Indian Armed Forces against Pakistan. Good. Then to tell the world how this Operation Sindoor was carried out, there was a Hindu Foreign Secretary. There was a Muslim Indian Army officer, Colonel Qureshi. And then there was a Sikh officer from the Indian Air Force. Is this only lip service? Because even then, on the grounds, minorities are being attacked, killed, and targeted in India. Clear? So this was what was posted by Professor. And Professor was arrested under section 152. Why? On the grounds that you are using electronic communication, which means he posted on his Facebook, used an electronic device. And through this, what he is trying to do, through these words, He is exciting or attempting to excite and encouraging separatist activities and endangering sovereignty and integrity of India. And that is why he was arrested. Now, whatever he said may not be good, may be bad, but does it amount to free speech, or does it amount to inciting people to violence? Or does it amount to promoting disaffection against the nation? Any honest criticism of the prevailing of the prevailing political situation in this country can be discussed by scholars, can be discussed by university professors. So we will see again the same pattern when section 124 capital A was misused, sedition. We will see the same misuse with section 152 because critics said that this law is nothing but same as that of sedition, which was part of the Indian Penal Code. But whatever it is, this is Article 19(1)(a) of the Constitution. And once we meet tomorrow, we will start with Article 19(1)(b) onwards. Till then, if you have any doubts with respect to 19(1)(a), let me know. Turn on the spotlight. Full gallery. Yes, any questions? Rahul.
Sir, I have a question. The untouchability part. And according to Article 17, if someone is preaching about untouchability, if he is preaching it indirectly, like I want Manusmriti to be implemented in the instead of Constitution. In Manusmriti, they say
Manusmriti is not only about untouchability or casteism. If it is only about caste system and the subjugation of Dalits, then yes, indirectly also you will be guilty of Atrocities Act. But Manusmriti is not only about it, although it has its imprint. Right?
Yeah.
Where are you from?
I'm from Mysore, sir. Settled in Bangalore right now.
Okay, so you're here. You should come someday in office. Let's meet.
Sure, sir. I'm looking forward to meet you. Thank
Yes.
you.
Thank you. Yes, anyone else? Prabhat.
Good evening, sir. I have questions from previous classes.
Okay.
So in last class, you mentioned that it's the discretion of the government to impose a reservation for such jobs and
provide reservation.
Yeah, provide reservation, and for some job they can deny. So what can be those job? You have mentioned, you have underlined TIRA or something like that. You wrote in the PDF.
Tata Institute of Fundamental Research. Purely research-based institutions, the government may not apply reservation policy.
So what jobs are there which do not
Any other
provide?
job, there can be reservation.
But
IAS, IPS, State Public Service Commission, bank jobs,
and
public
in
sector
Lakshmikant,
banks.
it's written that for scientific jobs, it's the discretion.
Purely research-based, not scientific jobs. Purely research-based institutions can be kept out of the purview of reservation because their merit rather than caste identity is required.
Okay, sir. And so for EWS, is it OBC creamy layer also included or it's excluded because they are not getting a reservation in any form?
What?
The OBC creamy layer, will it be included under EWS?
No, those who are eligible under the existing reservation, they will not get the benefit of EWS reservation. Now you are saying creamy layer is excluded from OBC reservation. Will they get EWS reservation? They are creamy. They don't fulfill the criteria of being poor. Hence, they will not get reservation.
Then won't it be sort of discrepancy between in one side you are including EWS people in the reservation, and the same time you are discriminating with those who are creamy layer because in more or less
this is a reasonable classification. taking into account if I am discriminating on the grounds of poverty, I'll give some benefits for poor and not to the wealthy. How is that irrational? It's a reasonable classification. Should I give subsidies to Ambani?
No.
Exactly.
So what's the criteria? Like 8 lakh income
8
and
lakh, 1200 square feet property in urban areas, 5 acres of land in the rural areas, agricultural land. If your father is from the State Public Service Commission holding constitutional posts, you are from creamy layer and you will not get the benefit of reservation.
that constitutional post, that clause is
Yes.
special.
Yes.
Because the same were for EWS who are getting
Yes.
reservation.
Yes.
And so before there was a class where you mentioned that there's immunity for president and government, the governor. So is it fully they are fully immune from civil proceedings, or there is 2 month that notice period? After that
If
notice
civil,
period,
for example, governor owes me 1 lakh rupees, it's not a crime. It does not fall under the purview of crime. It's a civil matter, civil dispute. I can file a case against governor, give me my 1 lakh rupees back. But for that, first I have to give him 2 month notice that you have 2 months, pay me my 1 lakh rupees back. Otherwise, I will file a case. That can happen. But criminal cases cannot be filed against the governor as long as they are in office.
so last question is, you just mentioned that Supreme Court, they have judicial review, the power of judicial review. So it will come under the article number 32, or it's something which is separate from article 32, the power of judicial review?
If it comes related to fundamental rights, then it is article 32. If it comes with respect to the laws passed by the parliament, then it comes under article 13 clause 2, because the state shall not make any law to delete or abridge fundamental rights. And if the state does that, it will be declared null and void. And this is where the power of the Supreme Court is, to review the acts passed by the legislature if they are in violation of fundamental rights.
So there will be 2 articles, 13 clause 2 and 32.
32. And if it is High Court, then article 226.
226.
Yes.
Okay, sir. Thank you, sir.
Thank you. Who is
sir,
next?
Sir,
Yes,
actually, I
Mehraj.
just wanted to confirm 2, 3. I have 4, 5 doubts. The first one is, sir, when we say under the Atrocity Prevention Act for that untouchability, sir, when we were saying that the FIR has to be lodged, okay, sir. So that means this is a compoundable offense. Can we say?
No, it is not a compound. It is not a compoundable offense.
Sorry, not compoundable. I meant then only.
Yes,
Yeah.
yes. It's a not
They
compoundable.
can't settle.
There can't be a
outside.
compromise outside. No.
And when we say that he has to be arrested at that spot only, that means it is a cognizable offense.
Yes.
So we can write this in exam and everything.
Yes, yes, yes.
Okay, sir. And sir, my next doubt is, sir, we were mentioning about right to flying flag. So it is recognized as inferred right under Article 19, Clause 1, Subclause A?
Yes.
Okay. Sir, my next question is...
But you don't say it is recognized as an inferred right. It has been inferred as a fundamental right, which means its status is same that is a fundamental right. That does not mean inferred rights will have less sanctity as the rights provided by the Constitution. It is same. It has been inferred as a fundamental right rather than it has been interpreted as an inferred fundamental right.
Okay, sir. Sir, my next question is, sir, regarding public order. We already discussed everything that state is hiding behind this figure of public order for banning films or not letting it in their states. Sir, what should be because we can't be, based on this few cases, we can't let the public order go in our answers or anything. So, sir, what is the balanced approach, sir? How we can justify?
The balanced approach is let a movie be screened, give it protection, give a space for the people to protest against that movie as well. Both exist at the same time. I don't want this Thug Life to be released. But once the movie has been signed off by the censor board, the Central Board for Film Certification, there are no grounds to stop the release of this movie. But then you can also criticize against this movie, criticize against Kamal Hassan, protest peacefully. without blocking those who want to watch this movie. This is where the state has the right to allow the screening of this movie, to allow a space for the protesters as well. Vent out your anger.
So that
Shout
means CBFC has to be more institutionalized and all stakeholders should be involved in certification process. Will that be?
There is no issue with the certification in this case, because the CBFC has cleared it. There have been instances where CBFC is deliberately not giving permission or release orders for a movie if it is critical of the government. We have seen instances where CBFC is asking for more cuts.
And
Various other movies, not just this movie, various other movies, it is asking for cuts. Blur this line, beep this phrase.
Okay, sir.
What do we do?
Sir, one thing is that heckling test you were talking about.
Now it is no longer in force.
Okay. So
now, even if there is one part of a movie or a book which is obscene, but the rest is perfectly fine, allow the release of this movie.
So Supreme Court is not longer endorsing to this test?
No. In fact, this test which originated in Britain, they no longer use it.
Okay, sir. Sir, and my last question is, when we were discussing about that POCSO, sir, about one example you were giving. So, sir, that person was married to a 14-year-old, the story that I'm talking about. Sir, it is a rape when it is just a marriage, or it is consummated or like that? Just marrying?
Number one, you should have asked me, how is this marriage? Because for a marriage to take place, the minimum age for a girl is 18. Right? So in such cases, let's say minimum age for a woman, for a girl is 18. Minimum age for a boy is 21. What if both are below the minimum age required for marriage? Is marriage void? Will it no longer be recognized as a marriage?
But it's a personal law.
Forget about personal. Let's assume these are Hindus.
Okay.
What happens to this marriage? Is this marriage valid? Or is it void?
It should
The
be void
marriage is
legally.
not void. The marriage is voidable.
No.
What is the difference?
Someone has to file.
If I was not someone, if I am a girl of less than 18 years, I was married. Will this marriage be legal? Yes. Will it be void? No. Then once I attain 18 years of age, I have 2 years. Within 2 years of attaining maturity, crossing 18, I can approach the court and declare that this marriage is null. That means it is not void, it is voidable. It can be terminated if it was done violating the law.
So, sir, locus
Marriage is
standi,
still valid.
locus standi is only with the groom and the bride only.
The locus standi is with the woman,
Only
is with the man.
Okay.
I can approach the court. This girl can approach the court. But marriage is still valid, which means the children born, they are legitimate. Now your question is this rape only if it is outside the marriage or if it is inside the marriage as well? Whatever, marriage or no marriage, it is rape, because a girl below the age of 18 cannot give consent.
Okay, sir. Sir,
And
it
if
is.
Supreme Court has to save you, it has to invoke Article 142.
Okay, sir.
Article
Sir,
142 is basically
complete justice thing.
Now, how do I explain complete justice? Here is, I have to send this person to jail according to the law. So if I don't want to, then there is only one option, which is 142. Otherwise, legally, I can't do it. Constitutionally, I can't do it.
Like what court did in Silas Shilpa case for their divorce, sir.
Yes. Or for that matter, there was a boy, Dalit boy, who qualified the JEE exams.
Yeah,
he had to pay 17,000 fee to an IIT. He could not pay it on time because the window for paying the fee got expired. He approached the High Court. High Court said, we can't help you because there are rules. Rules have to be followed. They are not discriminating against you because you're a Dalit, but because you failed to submit fee on time. Now you approach the Supreme Court. Supreme Court said complete justice 142. Even if there is no other option, you can still pay the fee and we will allow it.
Sir, my last question is a technical one related to this only. Sir, in these POCSO provisions, sir, we were earlier talking about penovaginal thing, right? So this also restricts itself to fornication, or it is applicable to all kind of penetration, sir?
Now, in case after the Nirbhaya gang rape in 2012, criminal laws were amended. Now, whether it is penetrative or non-penetrative, it is still rape. For example, what was the allegation against the Tehelka editor? You know that case?
Yes, sir.
What's his name?
I'm also forgetting. Some...
Long hair, beard.
Yeah, but her colleague only made allegation about that.
Yes, and there was no penetration, but fingers were used, and that was rape. So whether it is penetrative, non-penetrative, it is still rape if it is against the consent.
Okay, sir. Okay, sir. Thank you.
Thank you.
Sir, regarding to this, the minimum age criteria, Rishi Bhaiya.
Yes, yes.
Is it, did it come after the famous Rakmabai case, which appeared during the British India time?
Yes, after that as well. And then there were so many other cases. Initially, the age of consent was 12. Then it got increased to 40. Then it got increased to 60. Now it is increased to 80. And now there are demands of removing this or reducing it to 16 again. So Rakmabai was a landmark case in this case.
Okay. And I have two questions, one regarding Article 14 and the other is Article 17. Regarding Article 14, does it provide exception to judges as well? Because recently there was a news that K. Veeraswamy judgment. It was a news that it provided a judge's exception from the criminal proceedings. Why is
No,
it so?
the only exception was, it was not an exception that no case can be filed. The exception was you have to take the permission of the President of India before you can investigate. And that is not only for judges, it is also for public servants. Public servants under the Prevention of Corruption Act 1988. For example, tomorrow, Rishabha, you become an IAS officer. And as an IAS officer, you have to discharge your official duty. And your official duty is you have to allot flats to beneficiaries. And you are doing your duty. Now, Siddhant approaches the police and says, file a case against Rishabha because she has indulged in corruption. But you are doing your job. Prevention of Corruption Act says, unless and until the head of the department gives approval to the police, police cannot investigate you. Why? Because this law is meant to protect you. Otherwise, tomorrow, all the officers will stop doing their job. Why? Because if we give something to the beneficiary, if we solve someone's problem, if we resolve someone's grievance, case will be filed against us, corruption case. And then we have to appear before the police. It will be like harassment for you. That is why the law was amended in 2008 to provide for, unless and until head of the department gives permission to the police, no investigation can take place against you. Does that violate right to equality? No, it's a reasonable restriction. Reasonable restriction to protect you from unnecessary targets, from harassment, because you are doing your public duty. Similarly, if you're working at the central level, central government will have to give the permission to the police. Only then investigation can take place against you. If you're working at the state level, state government will have to give the permission. Now, what if there is some other individual? Then the person who is capable of removing you should be able to give permission to the police. For example, in the Mudda scam or alleged scam, when the case was against Siddaramaiah, the petitioners wanted case to be registered against Siddaramaiah. But who will give the permission to file a case against Siddaramaiah? Governor. Why? Because governor is capable of removing Siddaramaiah from his post. Because governor appoints chief minister, governor can remove the chief minister as well. This is Prevention of Corruption Act, meant to protect public servants while they are discharging their official duties from unnecessary harassment. And this is a reasonable restriction.
Okay.
This is not arbitrary. Same goes with the judges.
Okay. And if it is against public servants, for example, IAS officer, if it is for IAS officers and IPS officers, does it go to Central Administrative Tribunal or it will go to
So it
Supreme
won't
Court?
go to the tribunal. It will have to go to the government. The government will have to give the permission. Tribunal is when you have a dispute with the government with respect to your promotion, with respect to your seniority, with respect to your salary, increment, departmental action. In that dispute, you go to the tribunal. This is about permission, because here investigation will be done by police or CBI or LOPA or Lokayukta.
Okay, got it, sir. And the other about Article 17, I had a question that if no person of SC and ST community can be prohibited to enter the temple, why was Ramnath Kovind he was prohibited to enter the temple?
But then he did not escalate the matter, because later on he was allowed. Initially there was some hesitation, but then he was allowed entry.
Okay.
It would be an embarrassment if the president is filing a case that my rights have been violated, or Atrocities Act has to be invoked. It would be disturbing that way. That's why he played it small, played it lightly, downplayed it.
Got it.
Sir,
Thank
Hello,
you.
sir.
Sir,
Yes,
I
Mahi.
have a doubt from the previous class, sir.
Hmm.
In country-based classification in CA Principle 4, you said tomorrow if CA can be made constitutional, it can be in the grounds of religious minority. The government is focusing on religious minority. But even then, in the religious minority, government have excluded the Jews and atheists. So it is not a violation of Article 14 of intelligible differentia.
Very rightly, yes. I'm saying only on the grounds that it is a policy decision of the government, and the policy decision of the government is beyond judicial review. Why? There is an ongoing war between Israel and Hamas in Gaza. Then a petition was filed in the Supreme Court by Prashant Bhushan that their Supreme Court direct the central government. What? That if there are some private companies or public companies which are supplying weapons, ammunition to Israel, they should not be allowed to export. And if they are exporting, their export license should be cancelled. This was the petition before the Supreme Court. Why? Because the petition alleged that Israel is committing war against humanity and is destroying Gaza. Similar thing was invoked in UK as well, in Switzerland as well, in Netherlands as well, in Germany as well. And there the countries, they stopped exporting weapons to Israel. Why? Because they have an obligation that you cannot be participating in the war against humanity. But Indian Supreme Court dismissed this petition. On what grounds? Ground number one, that you are asking about Israel. Israel is a sovereign country. How can we dictate to a sovereign country? Number one. Number two, Supreme Court said you are asking us to ask the central government to stop giving them licenses. It may lead to breach of contract. Because what if these companies are under a contract to supply some weapons to Israel? For example, Adani Defense was supplying ammunition to Israel, and they have a contractual obligation. If we tell them don't supply them equipments, then Israel will file a case against them for breach of contract. And third, it is a policy decision of the government, and we don't interfere in the policy matters. So policy matters, policy making falls within the exclusive control of the executive, and Supreme Court in these cases exercises restraint. Unless and until it is blatantly unconstitutional, we will not interfere. But in some cases it does, some cases it does not. For example, there was a case when government decided we will give 122 2G licenses on first come first serve basis. We won't use auction. Whoever will come asking for the auction, they will have to pay the fee. We will give them spectrum, 2G spectrum. Supreme Court said, no, this is unconstitutional. You should go for auction, not first come, first serve, despite the fact that it was a policy decision. Dr. Manmohan Singh screamed that I don't want revenue from this 2G sale. I want increase in tele density. I want more and more people to get mobile phones. And for that, data rates should be cheap. Call rates should be cheap. Otherwise, why would they opt for mobile phone? And for cheap data rates, cheap mobile rates, I need to give more money, or I need to allow private companies to make money. If through auction they have to get the spectrum, that means they will outbid each other and the price will go up. Then this price will be diverted to the customers. Then we will have to pay more money, more charges for calls, for data. Manmohan Singh said, I don't want that. I don't want revenue maximization for my government. I want increase in tele density. Supreme Court said, no, go for the auction route. And after that, 3G, 4G, 5G spectrum has been auctioned. So sometimes court may interfere in a policy decision, sometimes it may not. I said only on this ground, it may be declared constitutional.
Okay, sir. And my second question is, sir, in intermarriage, both the parents can decide what is the, religion, interreligion marriage. Both the parents can decide what is the child religion, sir. But in the intercaste marriage, only a child has to get the father caste. Why it is cannot get the mother side caste?
That is why this matter has now been decided by the Supreme Court that we will have to hear it aggressively. Supreme Court has asked the opinion of all the states. Because in case of single mother raising a child, where in this case the mother was the OBC.
Yes.
So should the mother's caste be determining factor? And why should it only be on the basis of the caste of the father? Now let's see what the Supreme Court will have to say.
Okay, we have to.
There are rules are made. Rules can be good, bad, ugly, and it is for the court later to decide whether there is something arbitrariness in that. And if the Supreme Court says yes, it can be on the basis of the mother's caste as well. It will happen.
Okay. And sir, my last doubt is how CAA argument in against, sir, how CAA violates the Article 21, right to life and personal liberty.
How it does is, what if there are people who are Ahmadis from Pakistan? They belong to Muslims. They subscribe to Islamic faith, but they are under attack in Pakistan. Or there are Dawoodi Bohras, or there are atheists, or there are people belonging to different sects.
Yes.
Right? If they have taken shelter in India, now they can't get citizenship. Yes. We will have to send them back to Pakistan where their life is in danger. It violates the principle of non-refoulement, which Gujarat High Court, Delhi High Court has said is an integral part of Article 21. That's how it violates it.
Okay.
Okay?
Yes, thank you, sir.
Thank you.
Hello, sir. Hello.
Pavan. Okay, Kashi.
Sir, can I hearing?
Yes.
Sir, my question is regarding AWS reservation. Sir, I am a government employee in Karnataka government, Karnataka State Police. My income.
Your salary does not matter. Your father's salary matters.
Sir, my land is only 3 acres. My father is working agricultural. Can I eligible AWS reservation in UPSC?
Eligible, yes.
Okay, sir. Thank you.
Eligible.
Hello, sir.
Pavan.
Thanks, I am question regarding the case on Bharti judgment. Isn't it lose its credibility or effectiveness after the judgment of Nagraj? And Supreme Court also lose its jurisdiction over the reservation matter?
How?
In the Nagraj judgment, the 50% capping also removed on the regional.
No, Nagraj judgment did not remove 50% cap. Nagraj judgment allowed SC/ST reservation in promotion.
Am I wrong? There is some another case maybe, sir, which removed the 50% capping, AWS quota like you said.
Janhat Abhiyan, Supreme Court said 50% cap does not apply to EWS. 50% will apply if you're reserving seats for socially and educationally backward class of citizens. there don't exceed 50%. But there is a different criteria for EWS. That 50% cap does not apply here. And even 50% cap is not cast in stone. In exceptional circumstances, you can breach it. For example, Tamil Nadu said, if we have to give fair reservation, our majority population is socially and educationally backward. So how can you restrict it to under 50%? You have to allow us to make it 69%.
Sir, as far as reservation conceptualized on the basis of socially and educationally backwardness, then the why woman is not given reservation in the public sector till now. Even in the reserve category, horizontal reservation are also not provided.
No, there have been instances where women's reservation is provided in horizontal reservation in educational institutions. So there are states where 50% jobs are reserved for women. That is also constitutionally valid.
This are one more question regarding the SCS cap. Isn't in conflict with the Article 14 and the Article 19, sir? Where
Which Article 14?
Which talks about the right to equality, equality
But
before
right
law.
to equality does not only mean equality before law, it means equal protection of the laws. That means their intelligible differentia will come into the picture. Likes are to be treated alike. Unlikes are to be treated differently. So there are people who have suffered untouchability, who have suffered torture throughout history, generations after generations. They are kept separately from the rest. This is a reasonable classification, allowed under Article 14.
No, sir, as far as it is, if two person get in the conflicts, as you mentioned, the XY person, and when both person will approach to the police file a case.
Just because a law is misused does not mean that the law deserves no place on statutes. Misuse of law has to be curbed, and that can be done through training, through better awareness, quick justice. Even if there is a misuse, but our justice system is so quick that in 6 months verdict is given, then there is no misuse.
As
So we have to look at systematic reforms.
As we know, the case of Vishnu Tiwari, where Allahabad High Court set free after 18 years under the trial, sir.
Right. And there have been instances where people wrongly accused of terrorism have spent 20 years in jail. After that, they have been acquitted. Unfortunate, sad. But that doesn't mean we should not have anti-terrorism laws in India, just because there have been misuse in few cases.
Yes. Thank you, sir.
Thank you.
Hello, sir. Am I audible?
Yes, Shruti. Yes.
Yes, sir. So, what would be the procedure for obtaining information about a particular candidate, like who is contesting the election? Can this be done through filing RTI, or is there
No, RTI is not required. When they file election nominations, they have to file an affidavit as well. And then that affidavit is publicized as well. And that is how you see newspapers in Indian Express mostly. What is your asset? What was your asset in 2019? How much percentage increase we have seen in 2024? It is through that awareness. And it is popularized in the media as well. And you can get access to this affidavit as well. It is uploaded on the ECI website as well. And that is how you can make an informed choice. You don't have to file an RTI application to get this information.
So is this compulsory to every political leaders to give an affidavit?
110%. Without this, your nomination papers would be rejected.
Okay, sir. Thank you so much.
Thank you. Chirag.
Good evening, sir.
Good evening.
Sir, just out of curiosity, a question came in my mind that to curb corruption, we have an independent statutory body, which is Lokpal. Sir, why not we should make another independent statutory body which will control the transfer of civil servants, because right now civil servant work in the pressure.
There is a body for that as well, and that is called Civil Services Board, headed by the Chief Secretary of that particular state.
So right now, Ministry of DUPT controls their transfer, right?
But it is on the recommendations of the Civil Services Board, which is mandated by the Supreme Court in TSR Subramaniam case in 2014.
Okay. Oh, okay, sir. This was I wanted to ask. Thank you, sir.
And in fact, in the same judgment, Supreme Court said there should be a tenure for the IGP, for the Chief Secretary. It can't be less than 2 years.
Yes, sir, because often IPS officer get pressure from the ruling party member to release accused criminals from
Yes.
their party. Yes, sir.
Yes. But it is decided by Civil Services Board. And this is something that we will discuss in governance. There are states which have not set up Civil Services Board.
Yes, sir. Because politicians want to control them, so they don't want to
100%.
happen.
So even through Chief Secretary, they can control everything. So tomorrow, Chirag, you are the Chief Secretary of Karnataka. Siddaramaiah says that you do this. Will you not agree?
I have to, sir. I will not have any option.
Done. That
Yes,
answers your
thank
question.
you. Thank you, sir.
Yes, Jyoti.
Good evening, sir.
Good evening.
So I have a few questions. Sir, can you please throw some light on EV Chennaiya versus state of Andhra?
In that case, Supreme Court said states do not have the right to tinker with the SC/ST list. Because who grants you the status of SC or ST? President, based on the law passed by the parliament. So if states are allowed to tinker with SCs and STs, it means that the state is giving you a status of SC/ST, which you can't do. That is why this power is only with the parliament, with the center, not with the states. This is what was overturned in the Devender case, where Supreme Court allowed no, states have the right and the power to tinker with the SC/ST list. That is what we call subcategorization.
So in EV Chennaiya, the matter was the subcategorization only within the SC and ST. So now we can mention it in the answers that the judgment has been overturned now.
Yes.
Okay, sir.
Yes.
So what would be the ill effects of subcategorization and how does it differ with the vision of Baba Sahib Ambedkar?
Now, there are positives, there are negatives. Positives would be that within a caste, within a SCs and STs, they are not homogeneous, just like OBCs. So you can't be treating them as one block. There are castes within SCs, tribes within STs, who may dominate over each other. And to see now what is their proportion in administration, what is their representation in administration. Accordingly, we can decide that some tribes require less reservation as compared to others. This would be the pure social justice as envisaged by the preamble, by the constitution. But then it may also pit one caste, SC, against another ST. And this identity of Dalit will be further reduced.
Sir,
because no matter what you say, SCs are in one way homogeneous. Because all of them are Dalits. So if you further divide the Dalits, you are dividing the Dalit solidarity. Jatavs, non-Jatavs in UP. So if you're doing that, you're trying to dismember that Dalit identity, which goes against the Dalit movement itself. Because Dalit movement was an assertion. Assertion in the sense, we were called, or let's say Dalits were called achut, untouchables. And then Mahatma Gandhi said, no, you're not achut, you're Harijans, children of God. Then British came, they said, no, you are scheduled, you are basically depressed classes. Constitution said you are scheduled castes. Dalit said, don't call us scheduled castes or depressed class or Harijans or untouchables. We are Dalits. So it is the identity given by Dalits to themselves. And if you try to subcategorize castes, then you are weakening that Dalit identity, which is not good for them.
Okay, sir. Sir, understood. Sir, how does it differ from Baba Sahib's vision in the constitution? Can we?
It doesn't differ. In fact, Baba Sahib would be happy if subcategorization takes place, because he would never have wanted one caste to dominate over other castes.
So, but question if asks, then what should I do? Like, the question was specifically asking.
That's what I answered. Baba Sahib would be happy if subcategorization takes place.
Okay,
because
sir.
he was against non-dominance.
Okay,
And
sir.
even if there is one is what did Supreme Court say in this case? Supreme Court said, you are like people who have boarded the train and you have entered inside the train. And now you are trying to stop others from boarding the train. This is something that we will not allow you.
In
So you have
reservation.
the benefits of reservation by boarding